United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright citizens.
I understand that's what they said, but your test is the domicile of the parents, and that would be the test you'd have us apply today, right?
Yes, yes. So if a tribal Indian, for example, gives up allegiance to...
Born today, birthright citizens.
I think so on our test, yeah, if they're lawfully domiciled here.
Okay.
The man you just watched stumble is D. John Sauer, the United States Solicitor General, the government's top advocate before the Supreme Court. He came to the highest court in the land to argue that birthright citizenship has been misunderstood for 158 years. And the justice asking him questions is the one Trump appointed specifically for his constitutional expertise. What you watched wasn't a trick question. Gorsuch asked whether Native Americans, people whose ancestors predate the United States itself, are birthright citizens under the test Sauer wants the court to adopt. Sauer said yes, then no, then maybe, then said he'd have to think it through. That exchange didn't just expose a gap in preparation, it exposed the full reach of what the Trump administration is actually asking the Supreme Court to do, and who gets caught in the blast radius.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wong Kim Ark that followed with respect to temporary sojourners. And I take you've got your well-taken points. But there was, of course, John Marshall Harlan, the great dissenter, who dissented in Wong Kim Ark and later gave a bunch of lectures. And he posed the question about the sojourners. Suppose an English father and mother went down to the hot springs to get rid of the gout. And while there, they have a child, now back in England. Is that child a citizen of the United States, born of the jurisdiction thereof by mere accident of birth? And he says, under Wong Kim Ark, he is. And he continues, I was one of the minority, and of course I was wrong. Now, I'm sure that was tongue-in-cheek, but now, what do you do with that?
I'd say two things in response to that. First of all, he gave a speech, but we have 12 uncontradicted treatises that say the opposite, that is not what Wong Kim Ark means, and that's not the meaning of the clause. But also, I'd make a more fundamental point. When you're looking at Wong Kim Ark, one of the dissent has this dominant theme like you can't be doing this because you can't make and we all agree, or it's obvious, that the children of temporary visitors do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides the holding. So the court should be bound by what it says. This is what we're deciding. And again, on page 75, it says this is the single question. Now, there's been a lot of discussion up to that point, but at the very end, they said the single question we've decided is the citizenship status of the children of Chinese immigrants with a permanent residence.
Sauer's theory hinges on domicile. His reading of the 1898 Wong Kim Ark case says the court only granted birthright citizenship to children of immigrants with permanent residence and domicile in the United States. Temporary visitors don't qualify. Undocumented immigrants don't qualify. And under this reading, neither do their children. Gorsuch took that theory and applied it where it was never designed to go: Indigenous Americans. Tribal nations have a legal relationship with the federal government that has nothing to do with conventional domicile. For over 50 years after the 14th Amendment was ratified, Native Americans were explicitly excluded from birthright citizenship precisely because of the subject to the jurisdiction language Sauer is now invoking. They only became citizens by statute in 1924. So when Gorsuch asked, under your test, are they birthright citizens today? Constitutionally, not just by statute, Sauer couldn't answer. Because under the domicile framework, the answer is uncomfortable. And a theory that can't guarantee citizenship to the people who were here first isn't a constitutional theory. It's a tool.
And then
Not sure, I have to think that through, but that's my reaction.
I'll take the yes. That's all right. And then I just want to ask you quickly about the INA, adopted in 1940 and 1952. It uses the same term as the Citizenship Clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, by the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright. Would there be an argument for reading that statute under its original plain meaning at the time, 1940, 1952, to perhaps have a different meaning than the Constitution?
Sauer's statutory pivot reveals the real problem. He's asking the court to rule that immigration laws passed in 1940 and 1952, using the identical constitutional phrase, reflect a narrower understanding of birthright citizenship than Wong Kim Ark established. That would mean Congress passed those laws under a misreading of the Constitution, and no one caught it for 80 years. Justice Sotomayor offered the historical counterpoint that cut deepest. She reminded the court that the last time the Supreme Court narrowed citizenship rights for Native populations, the federal government went further and began denaturalizing people who had already secured citizenship. Sauer said the administration isn't seeking retroactive enforcement, but he couldn't say his theory prohibits it. That is the historical pattern. Narrow the definition, then apply it backward. Sotomayor wasn't speculating. She was reading from the record. Representative Teresa Leger Fernández said it most plainly after the hearing. Imagine going before the Supreme Court to attack birthright citizenship and being unable to say Native Americans are American citizens. This was never about the Constitution. It's about exclusion.
So you're really, at the end of the day, then, this is a straight-up constitutional ruling you want from this court, win, lose, or draw?
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we'd prefer an adverse ruling if the court's going to do that on a statutory basis and a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option, is the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Here is what this case is actually about. Trump's executive order targets undocumented immigrants and temporary visa holders. That's how it's framed. But the legal theory required to make that order constitutional doesn't stop there. It requires the court to adopt a reading of the 14th Amendment that, when applied consistently, cannot even guarantee citizenship to Native Americans without falling back on a 1924 statute. That is not a minor edge case. That is the entire argument collapsing under the weight of its own logic. Gorsuch saw it, not because he was looking for a political gotcha, but because he has spent years in the weeds of tribal law and knows exactly what the phrase, subject to the jurisdiction thereof, has meant in that context historically. He applied Sauer's test where it leads, and Sauer had no answer. If the administration's order takes effect, an estimated 250,000 babies born in the United States every year to immigrant parents would lose automatic citizenship. By 2045, researchers project over 2.7 million additional people living in the country without legal status. A permanent underclass, born on American soil, denied the rights that soil has guaranteed since 1868. The 14th Amendment was written to make that impossible. It was written specifically so that no president, no Congress, no executive order could decide which children born on American ground belong and which ones don't. The court is expected to rule by early summer. But the hearing made clear, when your legal theory can't protect the people who were here before the country existed, you are not arguing for the Constitution. You are arguing against it. Like this video, subscribe, and leave a comment. Who do you think the Supreme Court rules for? And what does it mean if they get it wrong?